Thank you. I'm trying to stall so that I have somebody who could move to waive the reading of the reports. So, we have the filing of committee reports, the secretary's report of committee filings. We have the secretary's report of committee filings.
Mr. Chairman, I move to waiver the secretary's report and the log.
Well, you can only do one at a time. There's been a motion by Councilmember Bonds, just in case anybody missed that, to waive the reading of the secretary's report of committee filings. Is there discussion on the motion? On the motion, all those in favor say aye. Aye.
Aye.
Are there any opposed? The ayes have it unanimously. We have the reading of the secretary's log of introductions and referrals. Again, I'll recognize Chair Pro Tem, Councilmember Bonds.
Thank you, Chairman, and I move to waive the reading of the secretary's log of introductions and referrals.
So a motion to waive the reading of the log. Was there discussion on the motion? All those in favor say aye. Aye. Are there any opposed? Hearing none, the ayes have it unanimously. If there's no objection, the first three measures for markup in the committee of the whole, which are confirmations of nominations to the Real Property Tax Appeals Commission, will be moved in block. They are PR 26-444, Real Property Tax Appeals Commission, Cliftine Jones Confirmation Resolution of 2026. PR 26-445, Real Property Tax Appeals Commission, May Chan Confirmation Resolution of 2026. PR 26-446, Real Property Tax Appeals Commission, Trent Williams Confirmation Resolution of 2026. Hearing no objection, all three are moved together. The mission of the Real Property Tax Appeals Commission is to conduct fair and impartial hearings on real property tax assessments for the citizens of the District of Columbia. That's citizens as well as businesses. The commission's objective is to ensure that an appellant's real property is assessed at 100% of market value based on properties similar in size and utility, so that an equitable tax burden is shared. The Commission on Real Property Tax Appeals meets at least 4 times annually for administrative matters. The Commission also meets in panels to consider appeals throughout the year. The Commission has, I believe it's 6 members, and then there are several hearing examiners who assist with regard to hearings. The purpose of PR 26-444 is to confirm the mayor's nomination of Cliftine Jones for reappointment as a full-time commissioner for a term to end April 30th, 2030. Cliftine Jones is a Ward 4 resident, and she has actually served on the commission for a number of years. This is, as I said, a reappointment. The purpose of PR 26-445 is to confirm the mayor's nomination of May Chan for reappointment as a full-time commissioner for a term to end April 30th, 2030. Ms. Chan is a Ward 6 resident, and she also has served for a number of years on the commission. The purpose of PR 26-446 is to confirm the mayor's nomination of Trent Williams for reappointment to the Tax Commission, and as the full-time chairperson of the commission for a term to end April 30th, 2030. This is a reappointment, but Mr. Williams was first appointed, if I remember correctly, right before the pandemic. So not as long a tenure as Cliftine Jones or May Chan. Each of these resolutions was introduced at the request of the mayor on December 4th, 2025, and the committee as a whole held a hearing or roundtable on these nominations on February 3rd, 2026. The committee has received no testimony or comments in opposition to any of these nominations. Without objection, I move the prints and reports for each, with leave for staff to make technical, conforming, and editorial changes. Is there discussion? The vote will be on the prints and reports for all three resolutions with leave for staff. All those in favor say aye.
Aye.
Are there any opposed? The ayes have it unanimously. Madam General Counsel, are these three measures legally and technically sufficient for our consideration?
Yes, they are.
Madam Secretary, is the record complete for each?
Once the reports and hearing records are filed.
And Madam Budget Director, these are nominations or confirmations, and so therefore there's no fiscal impact or fiscal impact statement, correct?
Correct.
Without objection, these three measures will be placed on the consent agenda for the March 3rd legislative meeting. If there's no objection, the next two resolutions will be moved in block. They are both appointments, confirmations of mayor's nomination for a reappointment of two members to the Washington Convention and Sports Authority Board of Directors. PR 26-475, Washington Convention Sports Authority Board of Directors, Julio J. Haddock Ortiz, confirmation resolution of 2026. And PR 26-476, Washington Convention and Sports Authority Board of Directors, Leif Dorms Joe, confirmation resolution of 2026. The Washington Convention and Sports Authority, otherwise known as Events DC, is the official convention and sports authority for the district. Events DC generates economic and community benefits for the residents and businesses of the District of Columbia by creating premier event experiences in the nation's capital and through the promotion of Washington DC as a world-class destination. Events DC's 12-member board of directors is comprised of local leaders from the district's business community who are appointed by the mayor and confirmed by the council, with the exception of 3 ex officio members. Board members serve staggered 4-year terms and represent specific business segments of the community. The purpose of PR 26-475 is to confirm the mayor's nomination of Julio J. Haddock Ortiz for reappointment as an individual with proven experience in tourism for a term to end May 16th, 2030. Mr. Ortiz is a Ward 6 resident, and he has served on the Events DC board for a number of years. And as I said, this is for reappointment. The purpose of 26-476 is to confirm the mayor's nomination of Leif Dormstrow as an individual with proven experience in municipal finance and as chairperson of the Events DC board. Although the resolution does not actually say as chairman of the board. Mr. Dormstrow is a Ward 3 resident, and he has served on the board. I think this would be his first full term. If I'm wrong, this would be his second term. The committee, both of these resolutions were introduced on December 9th of last year at the request of the mayor, and the committee as a whole held a public roundtable on these two on February 3rd, 2026, and the committee received no testimony or comments in opposition to either nomination. Without objection, I move both the prints and reports with leave for staff to make technical conforming and editorial changes. Is there discussion on the motion? The vote will be on the prints and reports for the two resolutions with leave for staff. All those in favor say aye. 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 Are there any opposed? The ayes have it unanimously. Madam General Counsel, are these two measures legally and technically sufficient for our consideration?
Yes, they are.
Madam Secretary, is the record complete for each?
Once the reports and hearing records are filed.
Madam Budget Director, these are confirmations and therefore no fiscal impact, correct?
Correct.
Without objection, these measures will be placed on the consent agenda for the March 3rd legislative meeting. The next item on the agenda is Bill 26-173. The fiscal impact statement has not been received from the Chief Financial Officer, so I am not moving that today. Give me a second. So the next measure is Bill 26-221, Mu Lambda Foundation, Inc., Real Property Tax Exemption Act of 2026. Before I move anything, I'm going to recognize Councilmember Parker.
Thank you, Mr. Chairman. I'm requesting to recuse myself for the consideration of this measure.
Right, I have no idea if you filed a statement, and I'm not sure I care, but the record will reflect that you're recusing yourself. I think you are absenting yourself. I believe you're absenting yourself. All right. The purpose of Bill 26-221 is to amend Title 47 of which is the tax code, to exempt from real property taxes the Mu Lambda Foundation House located at 2405 First Street Northwest, to exempt it from real property taxes for 30 years beginning October 1st, 2025 and ending September 30th, 2055. The tax exemption would be in effect so long as Mu Lambda Foundation, Inc. owns the property and the property is used for its charitable and educational purposes. The fiscal impact of this exemption was budgeted by the council last summer when we adopted the FY26 budget and financial plan. The Mu Lambda Foundation is a philanthropic arm of the Alpha Phi Alpha fraternity. The Mu Lambda chapter was chartered in the district in 1923. The foundation was established in 1994 and granted 501c3 status by the IRS in 1996. The foundation's headquarters are in the Bloomingdale neighborhood, which the foundation acquired in 1999. Rehabilitation of the property was completed in 2011. The property has been an operational home for the foundation's charitable activities since the rehabilitation was completed. This bill was introduced on April 3rd, 2025 by Councilmembers McDuffie and Parker. And the Committee on Business and Economic Development held a public hearing on the measure on November 19th, 2025. I believe there was no testimony or comments in opposition to the legislation, although I did not chair the hearing. There was something else I was going to say, which I don't remember now. So I move the print with leave for staff to make technical and conforming changes. Is there discussion? The vote will be on the print with leave for staff. All those in favor say aye. Are there any opposed? The ayes have it unanimously. The other thing I was going to say, which I probably should have said before the vote, was my understanding is that there was a TAFA prepared, and the TAFA did suggest that the tax exemption is not necessary. I will note that this was funded by the council as part of the budget. The ayes had it unanimously. General Counsel, no, I have to do the report first. I move the report with leave for staff to make technical, conforming, and editorial changes. Is there discussion? The vote is on the report with leave for staff. All those in favor say aye.
Aye.
Are there any opposed? Hearing none, the ayes have it unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed,
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
That is, the fiscal impact was covered in the budget.
Correct.
Without objection, this measure will be placed on the, looking at General Counsel, non-consent agenda? Because Mr. Parker is recusing himself. The non-consent agenda for the March 3rd legislative meeting. The next measure for markup is Bill 26-327, Schools First Amendment Act of 2026, called the Schools First Amendment Act of 2026. The legislation amends how DC Law 24-300, the Schools First in Budgeting Amendment Act of 2022, instructs the DCPS chancellor to construct the annual DCPS budget. Amends it in three respects. First, it requires that school budgets increase by the highest of the projected percentage increases in the foundation level of the uniform purpose student funding formula, the collectively bargained teacher salaries, or the average position cost. Previously, schools first required budgets to increase by the larger the UPSFF increase or the collectively bargained teacher salary increase, and did not consider changes to the average position cost. Second, the legislation no longer permits DCPS to reduce school budgets on the basis of eliminating school-based support personnel, which actually reflects what the practice has been, but clarifies the law in that regard. Third, it allows DCPS to reduce school budgets to account for a school or campus closure, including phased closures over multiple years. As with Schools First, the purpose of Bill 26-327 is to provide stability to school budgets and school staff. The proposed changes in Bill 26-327, along with adjustments to the committee's practices, which are discussed in the committee report when evaluating DCPS's adherence to Schools First. These changes will help provide additional stability and improve DCPS's accuracy when following Schools First law in budget formulation. This bill was introduced on July 11th, 2025, and the Committee of the Whole held a public hearing on October 1st, 2025. I want to say that the committee staff has worked with DCPS to modify the legislation as introduced and to reflect either in the report or in the legislation concerns that DCPS raised. I think with that, I will move the report with leave for staff to make technical and conforming changes. Is there discussion?
Mr. Chairman.
Councilmember Allen.
Thank you, Mr. Chair. I appreciate the work of you and your staff on this bill. I'd be remiss, though, if I didn't note that it's missing one thing, and that is the inclusion of the hold harmless legislation that would go to help our public schools and their budgeting so that when they go into a swing space and there is predictably a decrease in enrollment, which then means a decrease in funding for the schools, which then means they typically have to lay off or lose a position or two, only to return to a newly modernized school to great fanfare and celebration, and they see that enrollment rebound. In the interim, however, they lose the educators, the people who've built the relationships with the students, with the school, with each other and colleagues, and the hold harmless legislation is one that would help make sure that we provide that continuity for that 12 to 18-month period during that. I know we're not at the legislative meeting, so I hope that I can talk with you and we can keep working to include that in the first reading. But for our school communities, it's an important way that we are recognizing how valuable our educators and teachers are and not losing them in the short run of a move or a swing, which does long-term and damage when they're no longer a part of that school community. So I'm supporting this today and look forward to supporting it at first reading, but I also would like to work with you to include our hold harmless language, which was also a part of a hearing.
Thank you. Yes, and I recognize what the concern is with schools like, for instance, Brent, which is going through modernization, that we don't want them to be disadvantaged. So yes, I'm planning on discussing. In fact, I've asked my scheduler to see if we can meet this week.
Wonderful. Thank you, Mr. Chair.
Someone over here wanted to be recognized.
It was over here, Mr. Chairman.
Councilmember Henderson.
Thank you. Mr. Chairman, I wanted to ask, so I know at the October hearing, there was significant pushback from DCPS regarding the implementation of this bill. And in terms of the concerns about the schools first and budgeting framework in general, I think we had this discussion a couple of years ago around when are the implications, if ever, that a school budget can be decreased. So under this framework, which in my view, it only goes up. It can never go down unless the school is closed. Do you have any concerns about the long-term implications of actually funding this piece of legislation?
Well, actually, the Schools First formula does contemplate that it can go down when there's been a significant change in enrollment. And with regard to DCPS, I hesitate because I don't want to mischaracterize. I would say that they were much more supportive of the Schools First law at the hearing than they had been previously. They did raise a number of concerns, and we have addressed each of those concerns either in the report or in the legislation. For example, one of the concerns they raised at the hearing was that when there is, through the Schools First analysis, a change to a school's proposed budget of, and I think it was $62 was one school, they said really there's much more work involved in making that change. They wanted in the law that it could change by, let's say, $1,000. We didn't do that because we think that that's like automatically says you can reduce everybody's budget. But the report speaks to that and says that and the report, of course, is language that future committees can look at, says that the committee practice will be to treat de minimis changes as not being required. So that's just one example of a concern that they raised. I'm blanking at the moment on other concerns they raised, but as I said, we attempted to address each of them in either the legislation or in the report.
Okay. I also, in the fiscal impact statement for this, it was kind of curious to me that the CFO would suggest that funds are completely sufficient when we are requiring that the cost of the average teacher salary go up for inflation.
No, we're not requiring it.
That the increasing cost of a teacher salary be included in the budgetary calculation. Is that not accurate?
What this bill does is it says it includes in the formula, it's a choice of three: the increase in the UPSFF, or the increase in the teacher's contract, or the increase in the average position cost. Now, I think you know this, most members probably don't, that DCPS has a calculation called average position cost, which is not what the teacher actually gets paid. It's an average. And a couple of years ago, the average position cost went up by something like 17%. And you will remember that school after school after school complained that their budget might be going up, but that their buying power went down substantially because of that increase. So this fixes that. The average position cost includes a number of what I would call add-ons that I think actually we budget. I've had this debate with my staff. I think we actually budget twice for it. Something like fingerprinting for teachers as part of a background check. Most years, the average position cost has gone up like 2 or 3%. The way the formula works is it's the highest of those three. So think about it. If the UPSFF goes up, that means how much money the mayor is going to budget for schools. If the UPSFF goes up by 5%, then the school system gets 5% more money. And what Schools First says is, okay, well, then the school's budgets go up by 5%. That's a choice the mayor makes. If the teacher's contract goes up by, let's say, 3%, and let's say that's the highest of the three, then, well, the teachers are going to get paid more. So then the school's budget goes up by that amount. And the average position cost, as I said, until a few years ago, it wasn't an issue. But when it went up 17%, what we saw was schools losing their buying power. And that was very problematic. The purpose behind Schools First is stability in the schools, that schools can count on relatively the same budget from one year to the next. That was a long answer.
It's fine. This is important. Thank you, Mr. Chairman.
Thank you. Anything further on this, Councilmember Bonds?
Thank you, Chairman. I was just wondering, in the implementation of the Schools First requirement, is there a collection of data that would indicate what happens when, let's say, a school sort of downsizes or loses instruction as it relates to young people's test scores? Do we
The-
collect any of that kind of data that would tell us?
Well, there is data on test scores by school. I think your question is a little bit different. There's not
It
a
is.
report that does an analysis of,
Yes.
and I'm not quite sure what that would be, because all Schools First does is say that there is budget stability for a school.
Well, I guess I'm kind of stuck back where Councilmember Allen was. What happens when a school that's doing well then loses instruction because the enrollment has gone down, but you still have young people that are in that classroom environment. And I'm just wondering if we have taken the time to do an analysis that would inform us as to the value of keeping good instruction in a school. Because ultimately, our goal is to increase the educational attainment of our students. Yeah.
Sure. Well, one of the ways to do that is to retain staff, to minimize turnover of staff. What was happening before we had the Schools First law in 2022 was that there was higher turnover because schools were being told that they were going to have their budgets cut, and so staff would leave the school. And that is happening to a much, much less degree now. So there's more retention, and retention correlates with academic achievement.
All right, and so that sounds to me like there is some analysis that is in play. There is some data that is being collected that would cause us to take this approach to the educational process.
Yeah, I would add as well that I'm hesitating only because I don't want to speak for the school system, but I think DCPS has become more accepting of this and the stability, the financial stability with schools. Certainly from education activists in the community, we're hearing much more positive feedback with regard to the budget stability. I mean, just think back, and the committee report mentions this, in 2020, for fiscal year 2024, DCPS presented a budget in which half of the school's budgets were reduced. And remember, there was just
I
huge
remember, yeah.
blowback year after year
Yeah.
after year, and that has largely died down.
Yeah. I guess I'm just trying to bring home the point that there is analysis that supports what we are doing. And what we are doing as a government, as it relates to our school system, is attempting to right-size a school at the same time without creating harm to the student body or to what that school produces in the way of educated young people.
Yeah,
Thank you, Chairman.
thank you. If there's no further discussion, the vote is on the print with leave for staff to make technical conforming changes. All those in favor say aye.
Aye.
Are there any opposed? The ayes have it unanimously. On the report, I move the report with leave for staff to make technical conforming and editorial changes. Is there a discussion? On the report with leave for staff, all those in favor say aye. Aye.
Aye.
Are there any opposed? Hearing none, the ayes have it unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed,
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Is there a fiscal impact?
There is not.
Without objection, this measure will be placed on the consent agenda for the March 3rd legislative meeting. The next measure for markup is Bill 26-371, closing of a portion of a public alley and establishment of a building restriction line in square 2319 SO 22-02364, Act of 2026. Bill 26-371 would close a portion of the public alley system in square 2319, which is bounded by Utah Avenue, Northwest, Rittenhouse, 28th Street, and Nebraska Avenue. This is in Ward 4. The bill would also extend the existing building restriction line in Lot 77 over the portion of the closed alley. According to the property owner, the closure would enable the beautification of the closed portion of the public alley, which abuts the portion of the land formerly owned by the Episcopal Church for Children that was recently purchased by Murray School, and would also clarify title to the land. Reading from the report, the committee finds that the portion of the alley system in square 2319, as shown on the surveyor's plat for this SO file, is not necessary for alley purposes. This legislation was introduced on September 29th last year, and the committee of the whole held a public hearing on January 13th, 2026. As I recall, there was no testimony or comments in opposition. In fact, looking at the report, there were only government witnesses. I move the print with leave for staff to make technical and conforming changes. Is there discussion? The vote will be on the print. All those in
Chairman,
favor?
you didn't look down.
What's that?
You didn't look down.
I did not. I looked down. I looked down right in front of me. Councilmember Lewis Drudge.
Thank you, Chairman. And thank you to the committee for marking up this, moving this measure forward. This legislation closed a small, what we like to call ghost alley in square 2319 behind 5931 Utah Avenue Northwest. The alley was deeded to the district in 1934, but in the roughly 90 years since, it has never been used as a public right-of-way. It has long been fenced in and functionally absorbed into the surrounding yards with no realistic public purpose now or in the future. Closing this alley, though, solves a few practical problems all at once. It will allow for buffering landscape between the nearby property and Murray School recently leased athletic field and clubhouse, which will help preserve privacy for neighbors and the school. It also clears up a title issue that has complicated property transactions because the alley's purpose and history have been unclear. And it resolves a zoning issue. Without this narrow strip included, the side yard is non-compliant under district zoning requirements. So incorporating it brings the site into compliance. Finally, once this land is conveyed into private ownership, it will generate annual property tax revenue for the district, converting an unused strip of public land into a taxable asset. This is a targeted common sense fix that clarifies ownership, supports the neighborhood's compatibility, and puts long unused land to productive use. So I want to just thank you again, Chairman, for moving this along, and thank members of the Chevy Chase community who have advocated for this. Thank you.
Thank you, Councilmember. If there's no further discussion, the vote will be on the print with leave for staff to make technical and conforming changes. All those in favor say aye. Aye. Are there any opposed? Hearing none, the ayes have it unanimously. We have the report. I move the report with leave for staff to make technical, conforming, and editorial changes. Is there discussion? All those in favor of the report with leave for staff say aye.
Aye.
Are there any opposed? Hearing none, the ayes have it unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed,
Madam Budget Director, does the measured physical impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today, or for the March 3rd legislative meeting. The last item for markup in the committee of the whole is Bill 26-426, Holding Company System Amendment Act of 2026. Bill 26-426 would amend the Holding Company System Act of 1993 to update the group capital calculation for the purpose of insurance holding company system group solvency supervision, and add a liquidity stress test for macroprudential surveillance. It would also provide the DISB commissioner with additional authority over third parties in the event an insurer is in hazardous financial condition or placed in receivership. Bill 26-426 would incorporate the most recent National Association of Insurance Commissioners accreditation requirements. In 2020, as part of its ongoing model law developmental activities, the National Association of Insurance Commissioners, or NAIC, adopted revisions to the holding company law and regulation, establishing group calculation, filing requirements, and liquidity stress test reporting. To maintain compliance with the NAIC's accreditation process, these revisions were required to be adopted by all U.S. jurisdictions before January 1st, 2026. However, the committee understands that the NAIC has credited the district with having advanced the bill through the legislative process before that deadline, and passage now will not adversely affect DISB's accreditation. This legislation was introduced at the request of the mayor on October 8th, 2025. The Committee on Business and Economic Development held a public hearing on the measure on November 19th, 2025. And it appears from the committee report that there was no testimony or comments in opposition to the bill. I move the print with leave for staff to make technical and conforming changes. Is there discussion? The vote will be on the print with leave for staff. All those in favor say aye. Aye.
Aye.
Are there any opposed? Hearing none, the ayes have it unanimously. I move the report with leave for staff to make technical, conforming, and editorial changes. Is there discussion? All those in favor say, of the print, say, yeah, just say. I did the print. I already did the print. All those in favor, I lost track of myself here. I think we've already voted on the print. The vote is on the report with leave for staff. All those in favor say aye.
Aye.
Are there any opposed? The ayes have it unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed,
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Is there a fiscal impact?
There is not.
Without objection, this measure will be on the consent agenda for the March 3rd legislative meeting. That completes the measures for markup in the committee as a whole. Turning to measures from other committees. From the Committee on Youth Affairs, all of these measures are from the Committee on Youth Affairs. PR 26-358, Director of the Child and Family Services Agency, Tanya Torres-Trice, Confirmation Resolution of 2025. Councilmember Parker.
Thank you, Mr. Chairman. This resolution advances the mayor's nomination of Acting Director Tanya Torres-Trice to assume the permanent directorship of the Child and Family Services Agency. Ms. Torres-Trice is a licensed social worker with over 20 years of experience working on behalf of children and families. Her experience includes 17 years at CFSA, including as Assistant Deputy Director and Administrator for the Office of Youth Empowerment, and most recently as CFSA's Chief of Staff. In writing about her interests in the directorship, Ms. Torres-Trice shared that she is, quote, driven to lead CFSA to strengthen our community partnerships, address systemic issues, and ensure that every service decision is made with the child's and family's best interests in mind, end quote. Ms. Torres-Trice is also a Ward 5 neighbor. The committee found that Ms. Torres-Trice is significantly qualified for the role and recommends her approval or approval of this confirmation.
Thank you, Councilmember. My understanding is that this was deemed approved on February 12th.
That is
So
correct.
my question, I think, to the Secretary or General Counsel is, do we agendize this, given that it's already been, I mean, I think there's a value to you presenting it today. I would suggest that we not agendize it, Madam Secretary.
yes, Mr. Chairman, no, it cannot be agendized because the matter has been passively approved.
But the limbs will reflect the committee report.
Yes, Mr. Chairman.
All right. So I'm going to move on to the next measure, which was reported out of the Committee on Youth Affairs, is Bill 26-398, Increasing Support for Grandparent and Close Relative Caregivers Act of 2025. Councilmember Parker.
Thank you, Mr. Chairman. This bill increases the grandparent and close relative caregiver subsidy to $38 a day in fiscal year 27 and adjusts for inflation annually thereafter. This bill was the result of numerous grandparents and close relative caregivers sharing with the committee about the significant costs they take on when they step up to take care of children in their home at a time of immense need. It is important to understand that the rate for these subsidies hasn't changed in roughly a decade. The current full subsidy payment without TANF benefit offsets is $24.79 per day for children younger than the age of 12 and $27.92 per day for children older than the age of 12. Given the ever increasing cost for raising children in the district, this legislation seeks to address financial struggles head on for these caregivers and bring it in line with the foster care subsidy. Thank you, Mr. Chairman.
Are there questions from members? Councilmember Lewis George.
Thank you. Thank you for continuing the council's strong tradition of fully supporting the grandparent and close relative caregiver program with this bill. I wanted to ask about CFSA's implementation of the Grandparent and Caregiver Subsidy Eligibility Expansion Amendment Act of 2023, which my committee funded in the fiscal year 24 Budget Support Act. Late last year, CFSA informed both of our offices that since October 1st, 2024, that the agency was not offsetting SNAP and other listed benefits from determinations of eligibility, claiming they were unaware this change was made in the BSA. Last month, CFSA said it was still deciding whether it was going to retroactively apply the offset to affected participants and applicants as the law required, or if it would do so only moving forward. Can you share whether CFSA has decided to retroactively apply the offset to bring the agency in compliance with the law? If they are retroactively applying the offset, has CFSA given a timeline for when that will be complete?
This came up at a recent oversight hearing, and it is our understanding that they are not offsetting the subsidies for anyone at this time. And
But are they moving forward with the change?
there was no commitment to offset moving forward. And so one of the things that we were seeking to do with this legislation was to strike that requirement altogether, that they must offset for the first 60 months of participation so that caregivers could maximize the subsidy benefit.
So the policy decision moving forward is that they won't be offsetting like SNAP and other listed benefits from determination eligibility.
That's right. That's right.
Wow. Okay. That's a shift or a change. Okay. And I also wanted to, I didn't get a chance to speak last time, but I want to say I firmly support the decision for Director Teresa's appointment. I found working with her, she is an expert in the field and cares deeply about the community. You didn't recognize me the last round, so while I had this time, I was going to utilize that. Thank you.
I will say that CFSA, while they have not endorsed this legislation, they have on the record said they support increasing the subsidy. It's a matter of funding, and this comes at a cost.
Councilmember Crawford.
Thank you, Mr. Chairman. I look forward to supporting this legislation, and of course, I want to thank Councilmember Parker for your leadership on this pack of bills. As I mentioned during the Committee on Youth Affairs markup, I do continue to have concerns about the fiscal impact of this bill, which will cost $6 million in fiscal year 2026 and $25 million over the financial plan. I fully understand that we need to increase the subsidy because the rate hasn't changed in roughly a decade. And with CFSA expecting the number of participants to remain steady even after the changes made to this bill, I just want to name that I look forward to working with you, Councilmember Parker, and members of the committee as we take up the budget to see if we could get more participants and maybe get the costs down. And I would like to give you the opportunity to respond here at Cal to those concerns.
Yeah, I'm going to pull out the question there. Thank you. I will say two things. When we originally introduced this bill, it also included extending eligibility for families to the age of 21 years for the child. We struck that given the cost parameters. And you're right, this comes at a significant price tag. And it will be a matter of making decisions in committee and as a council to see how we can fund this. I think it is worth noting, it is the priority of our CFSA, or our Child and Family Services Agency, to keep as many children with their families. The research is clear. Children thrive and fare better when they are with loved ones and close relatives. However, when you look at the grandparent and close relative subsidy in comparison with the foster care subsidy, there is a significant disparity. And so what that says to me is our stated priority isn't in alignment with our funded laws. And so what this bill is seeking to do is to try to right-size that. And you're absolutely right, it comes at a cost. And so I'm gonna be looking forward to working with you in the budget to see how we can try to fund this.
Thank you. I appreciate that.
Further questions? I have three. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
And there's a fiscal impact?
There is, as we just discussed, 6 million in FY '26 and 25 million over the plan.
Without objection, this measure will be placed on the consent agenda for the March 3rd legislative meeting. Bill 26-404. State Pregnancy, Delivery, and Postpartum Care for Youth at DYRS Amendment Act of 2025. Councilmember Parker.
Thank you, Mr. Chairman. This bill requires that DRS make pregnancy testing available to youth upon admission to any DRS facility, such as the Youth Services Center and New Beginnings, as well as pregnancy testing when necessary for the prescription of certain medications. The legislation sets the standard of care for DRS facilities to ensure timely, culturally responsive, and comprehensive care for pregnant youth. These measures aim to fill a gap in healthcare protocols at DRS currently, which have fallen short from national standards. It is unfortunate that this approach to healthcare has not been more intentional nor consistent at DRS, but the hope is that this bill will set the foundation for expectations for young women in the agency's care. Last thing I would just say, Mr. Chairman, this legislation brings our juvenile detention system in alignment with our adult detention system, given that there was similar legislation passed for pregnancy protocols at the Department of Corrections, I believe 2 years ago. Thank you.
Are there questions from members? Councilmember Bonds?
Thank you, Chairman, and to Councilmember Parker. Just wondered, what is the funding that's required?
Yeah, fortunately, the FISC came back saying that there are sufficient funds for this bill. It is worth noting that there is some protocols in place, but they're disjointed and they're not applied evenly. One of the reasons that I was moved to introduce this is that the OIJJFO found in a recent report that 12 youth were prescribed medications without any insight to whether or not they were pregnant, and the medications would be harmful if they were in fact pregnant. So to answer your question, there is zero cost for implementation, and the agency has said they're committed to aligning with the goals of the bill.
Good deal. Thank you.
Any further questions? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Is there a fiscal impact?
There is not.
Without objection, this measure will be placed on the consent agenda for the March 3rd legislative meeting. Bill 26-407, Strengthening Capacity and Transparency at DYRS Amendment Act of 2025. Councilmember Parker.
Thank you, Mr. Chairman. This bill accomplishes three important goals. It requires regular reporting on youth demographics and incidents at DRS. It defines recidivism and tasks the agency with publishing rates of recidivism in 1, 2, and 3-year increments. And it directs the mayor to create an action plan to address systemic overcrowding at the Youth Services Center within 120 days of the bill's passage. In effect, this bill will ensure the council retains important juvenile data that was previously reported by the OIJJFO. A recent report revealed that 78% of youth who were committed and released from DRS facilities in 2023 were found to have later justice system involvement. Put differently, nearly or more than 3/4 of the young people that we are detaining are coming right back to the agency, which is why we're hoping to get a better grasp of things with the reporting on recidivism. And then ultimately, we want to address routine and systemic overcrowding at the agency, as it is both dangerous but presents further complications for services being provided to young people in the care of DRS. Thank you.
Thank you, Councilmember Parker. Councilmember Henderson?
Thank you, Mr. Chairman. I do have a couple of questions I wanted to ask. Councilmember Parker, the Office of the Independent Juvenile Justice Facilities Oversight reports on daily population data, both at YSC as well as at New Beginnings. The agency is now, well, office rather, is now housed under the work of the DC Auditor, which completes incident reports and safety reports. How is this bill not duplicative of their work?
Great question. We did away as a council with the OIJJFO. Through the work of the committee, we got DRS to agree informally to report some of the data metrics that the OIJJFO was reporting. It is important to note that we did not fund the auditor components of the OIJJFO. And so right now, there is a handshake agreement in us receiving this very valuable information. And part of this legislation is to require it even beyond the current leadership and the agreements that we have moving forward.
So if I'm forecasting forward, because we're about to go through this next budget process, are we essentially saying that because DRS is going to be taking on these reportings in-house, that the independent juvenile justice facilities oversight work is no longer formally needed?
The office no longer exists. So it sunsetted at the end of last fiscal year. There was a gap in time when there wasn't reporting. Given our oversight with the director, and I want to give him kudos, he is willingly reporting many of the reports that the OIJJFO reported, but that is currently a handshake agreement. So with new leadership, a new mayor, administration, they can say, we're not going to share this. And these reports, including incidents, population, et cetera, are vital for us to keep a grasp of what's happening.
Let me change my question just a little bit. I think there was value in having an independent
Yes.
body sort of doing that work. Do you feel confident in that the agency that for which there is an incident is also going to accurately report on said incident about their agency?
Great question. I have full confidence. I have full confidence that DRS will attempt to accurately report information. I do think there's still a need and value to an independent oversight agency. Again, we didn't fund that as a council. I think it's important to remind people, the auditor made it very clear that she did not want that function as part of her office. There is still a need and value to independent oversight in addition to what the council is providing. One of the things that I would just stress would be a value add is oversight of the many facilities across the country where young people are being placed that currently go without much probing. I'll just say that.
Thank you. Thank you, Mr. Chairman.
Thank you. Councilmember Robert White?
Thank you, Chairman. Thank you, Councilmember Parker. This bill requires public reporting on things like population incidents, recidivism, safety, and requires a a plan to address overcrowding. My understanding is that the administration opposed this bill citing capacity concerns and that there is a fiscal impact on the first year of more than $250,000 and then like $658,000 over the financial plan. Are these things not being done right now?
Again, you're pointing to an ongoing issue. Yes, the FIS says that DRS needs extra FTE to do the stuff that they're already doing. I think it is important to note that the director agreed to populate the data on the DRS website per the request of me and the committee. That agreement is temporary. With a new mayoral administration, they may say, we don't want numbers being reported publicly. And so that is why this is important. I would also say part of the FIS speaks to a contractor that the executive office would need to hire to create a plan to address overcrowding. Now, again, I don't think we need to hire someone to come up with a plan that should already exist. Today, fortunately, we are under capacity at YSC, but for 88% of the last year, YSC was overcrowding. In
Right.
that 98-bed facility, there were more than 24 more young people being stuffed and stashed in different places. So those are the two areas where the FIS is reflecting a need for additional resources.
Okay, I appreciate it. That's incredibly concerning that we need to hire somebody to figure out how to address an overcrowding issue that's years long.
Yes.
That's really concerning. Thank you, Chairman. Thank you, Councilmember Parker.
Thank you. I have one question. Councilmember, you said that the bill was defines recidivism and then requires a report on data at 1 year, 2 year, and 3 year. How did you pick 3 year? Why not, let's say, 5 year? And did you do a comparison with other jurisdictions so that the data can be compared to other jurisdictions? I'm just kind of, for example, and I don't know if this is correct, let's say that Maryland has data for 1 year, 2 year, and 5 year. If we're at 3, we can't make a meaningful comparison. So how did you come up with 3, and did you look at other jurisdictions?
The 1, 2, and 3 year metrics came in consultation with DRS leadership, the mayor's office, and the Office of the Attorney General. One of the issues we continue to run in, and Councilmember Pinto can also speak to this, is everyone defines recidivism differently. And, at regionally, but also here locally. And so we also define what recidivism means for juveniles, which essentially is that they are arrested for a new offense after being released from detention, and we will track that on 1, 2, and 3 year metrics. That was the request of DRS leadership. We got the buy-in from the OAG, and those benchmarks were the agreed upon terms.
Could you look at, between now and first reading, other jurisdictions and see if they have something beyond 3 years so that we
Happy to.
can make comparisons?
Happy to.
If there are no other questions, Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Is there a fiscal impact?
There is. It is 234,000 in FY '26 and 658,000 over the financial plan.
Thank you. Without objection, this measure will be placed on the consent agenda for the March 3rd legislative meeting.
Mr. Chairman, I have a question
Yes.
before we vote, and I'm happy to take this offline. Is there a process for us to renegotiate the FIS after we vote on it?
Well, we're not voting on the FIS.
Well,
But,
meaning vote on this?
Yeah, go back to the OCFO and tell them why you think the FIS should be lower.
Got it.
You could also work with the budget director.
Yep.
The budget director has some expertise or experience in trying to negotiate FISs. Bill 26-409, Empowering Parents in CFSA Investigations Amendment Act of 2025. Councilmember Parker.
Thank you, and I think this is the last one, Mr. Chairman. This bill requires the Child and Family Services Agency to make 3 notifications to caretakers during the initial phase of an investigation, inform caretakers of their right to counsel during legal proceedings, provide them with a list of available legal resources, and then alert them to the availability of the Office of the Ombudsman for Children as a resource for complaints. While the right to counsel during child welfare proceedings is already enshrined in DC law, the committee has received numerous reports that many parents are not aware of this right until proceedings begin. At that point, parents may have lost the opportunity to preserve evidence and fully participate in their defense. This bill promotes equitable outcomes in CFSA investigations by ensuring that parents immediately grasp the full scope of their rights and maintain access to a channel for complaints as soon as the process begins. With these requirements in place, parents can fully engage with the investigation process and respond to CFSA inquiries. Thank you.
Thank you. Are there questions from members? Councilmember Lewis George.
Thank you. Councilman Parker, some witness testimony indicated that this bill will guarantee the availability of representation when a CFSA investigation begins. Currently, a right to legal representation exists only during legal proceedings. Can you confirm this bill does not create a new right to legal representation during a CFSA investigation and keeps the existing right to counsel during legal proceedings?
That is right. There was some advocacy to establish the right to counsel at the beginning of an investigation. The committee determined that that was not feasible and could have negative consequences on the capacity of the courts. And so this bill requires that CFSA notify parents that they are under investigation and then to share rights and resources with them. Their right to counsel would begin once the legal proceedings were to start.
Legal proceedings, okay. And then I know CFSA currently has information on legal resources available to families involved in the child welfare system, but families have often say the information is insufficient to understand all resources available and how to utilize them. How would you assess CFSA's current list of legal resources? And does this bill require, or has CFSA indicated they are open to changing the substance, format, or means of sharing legal resources?
Yeah, CFSA did express agreement to adapting their current brochure and information. One of the things that we made a point to stress is that at the very beginning of the process, parents must be informed because there was a loose interpretation of the phrase at the beginning of the process. That could be weeks after it originally started. So we want it to be at the very beginning, but also to ensure that agencies and nonprofits that do this work pro bono are included. And so that's also why it's important that we included the Office of the Ombudsman so that parents had an avenue there to share their complaints, but also get information to resources.
Understood. Thank you so much.
Thank you. Any other questions? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Is there a fiscal impact?
There is not.
Without objection, this measure will be placed on the consent agenda for the March 3rd legislative meeting. I hate to say it, but we're at the end of our agenda. I know, we could stay here longer. I think a member's asking if I could move the recess instead. So the next meeting is scheduled for March 3rd, 2026. The time is 2:05 PM and this meeting's adjourned.
Then you can do a motion. Consider it.